Good evening. My name is Yvonne, and we are going to have a fantastic time this evening talking more about legacy planning. We're going to go through a few things tonight as we welcome our speaker, but we're going to provide a welcome from our chapter president, and then we're going to do a spotlight on our founding principle of Finer Womanhood with Miss Cheryl Swan. And then we're going to introduce you to our speaker for this evening, and she'll go through her presentation. We'll have some time for Q&A at the end, and then we'll wrap up and give you some time back in your evening so you can go ahead and enjoy that. So now I'm going to turn it over to my wonderful, well, actually, excuse me, before I do that, I'm going to introduce our chapter president, Mrs. Christian Lloyd, and she's going to welcome you officially to our program this evening.
Greetings. On behalf of the ladies of the Kappa Zeta Chapter, I would like to welcome you to our Finer Womanhood Legacy Planning Series. Thank you so much to the committee for providing this platform, and thank you to the presenters for the wealth of knowledge. We hope that this information is informative to you and your family, and you will be able to have those conversations about life to ensure that you have made the right decisions for your loved ones. Thank you so much for attending tonight, and have a wonderful night. Thank you.
And now I'm going to turn it over to Mrs. Cheryl Swan to speak with us about Finer Womanhood.
Thank you so much, Sarah Odembe. Finer Womanhood is one of the 4 founding principles of Zeta Phi Beta Sorority Incorporated. Finer Womanhood represents character, integrity, and persistence. In the Kappa Zeta Chapter, we believe a finer womanhood encourages community consciousness and empowers the citizens of her community. We also feel that a finer woman protects her family even in the event of her death. It's how she cares for her loved ones. As finer women, we strive to equip our communities with the information needed to guard the futures of their families. Over the next few weeks, we'll cover financial planning, legal planning, and dealing with grief and bereavement at the end of life. So now I'll turn it over to our presenters today so we can start our lecture series. Yvonne Odembe and Getsi Aredo. Thank you.
Well, actually, what I'm going to do, thank you, Mrs. Swan, I appreciate that. Actually, what I'm going to do is turn it over to Angie Rito Huff, my sister, to introduce our speaker for this evening. Angie, you want to take it away?
Good evening. My name is Angie Rito Huff. Today I have the honor of introducing attorney Yvonne Kafor, who will be sharing her ideas on the legal aspects. Yvonne, who was born in Charleston, Illinois, but raised in Lagos, Nigeria, moved back to the United States 25 years ago. She obtained her law license in 2007 and began her legal career as a probate attorney. Yvonne is the principal and owner of Kafor Law Firm PLLC, a Dallas-based family and personal injury law firm. In addition to her law practice, she is a certified divorce and custody coach. She also works as a youth director for the Collin County Black Chamber of Commerce, developing initiatives that encourage young people to discover their purpose and strive to be the best version of themselves. Yvonne and her husband of 15 years have 3 beautiful children, Natalie, 13, Jason, 11, and Olivia, 8. Together, they co-direct Florence Youth Development Program, a nonprofit organization dedicated to educating, guiding, empowering, and assisting vulnerable African youths in reaching their full potential. Yvonne enjoys cooking, organizing youth events, traveling, having breakfast with her closest girlfriends, watching her son play competitive soccer, going to the gym, and most of all, spending time with her family. I will now pass it on to attorney Yvonne Kafor.
Thank you so much. Good evening. I'm so honored to be here with you all today. And you know, sometimes when I ask myself what I would do different if I had another chance to go to college, I'll tell you that what I come up with is that I should have joined you beautiful ladies while I was in college. And so I am really honored to be the presenter today. I want to thank Yvonne and Getsy for being so patient with me through this process, and also just giving me a chance to come out here and talk to you ladies, and I think there's some gentlemen here, about some of the most important topics that we all need to be having while we are alive for different reasons. But I would touch on three main reasons. It would be to save money, to save our loved ones time, and to also save them the stress of probate court and the legal system. And so today we're going to get into discussing 8 very important Texas estate planning documents. Yvonne, if you want to go ahead and start that slide for me. I want to talk about my disclaimer. This is important. All of the information that I provide today on this forum does not and is not intended to constitute legal advice. Instead, all the information, the content, and the materials that I provide to you today are just for general informational purposes. And so if you have any legal issues concerning a probate matter, concerning a guardianship matter, or any matter at all, it's very important that you discuss with a licensed legal attorney in whatever state you're in. If you're in Texas, and so I'm giving information today, and I'm happy to answer questions at the end, but it does not take the place of legal consultation with an attorney. Go ahead, Yvonne, to the next one. All right, so I talked to you about the planning documents that we're going to be discussing today. There are 8 of them. There's several more documents, but I've outlined these 8 documents because I feel like they're the most important for each and every one of us to have in our estate portfolio. And so the first one we're going to discuss today is will. And before I get into talking about will, because I know everyone here has heard about a will. Everyone knows what a will is, but I want to talk about a story that would help you understand why I'm talking about the elements of a will in Texas. And so a few years ago, I had a young man come into my office. He's about 28 years old. This young man was raised by his stepmom, who never adopted him. And so father died before stepmom. Stepmom, before she married the dad, the young man's dad, she owned a property, a real estate property, and that's where they all lived, and that's where this young man grew up. And so father died, and then stepmom died. Prior to stepmom's death, she went online and she was able to create what she thought was a will. And so when she passed away, the young man came to my office and he wanted us to help him probate the will. The problem he had is he had a will that was not probatable. It was not going to go through the court system. He was not going to be successful. And so he was stuck. The properties that his stepmom owned were not going to come to him, even though that's what she really wanted. And so if you go on to the next slide, we'll talk about why that was an issue, what issues that young man had with his will, with that will. And so in Texas, you have to have several elements in order to constitute a legal will in Texas. And so the testator must have legal and testamentary capacity. In other words, for you to draft a will, you have to be at least 18 years old, you have to be lawfully married, or you have to be a member of the armed forces. See, the young lady, the young man's stepmom satisfied the legal capacity. She was over 18 years old. Then the next question is, was she of sound mind? And Texas courts have rules that sound mind will be if you know exactly the effect of making a will. In other words, do you know what your will is going to do at your passing? Number 2, do you understand that you're making a will? Do you understand that whatever you put in that document means that would be what will happen at the time of your death? Number 3, do you know the nature and the extent of your property? Are you able to outline what properties you own? A home, a car, money in the bank account? And do you know who your relatives are? That particular will satisfied the testamentary capacity. She was of sound mind and she was able to outline all of these elements. She knew who her relatives were. She was able to name that young man as a stepson. She was able to outline all of her properties, the address to that particular house. And she knew and understood what would happen at the time of her passing. The next question is, did she satisfy the formalities of a will in Texas? So while you go through the legal capacity, you have the testamentary capacity. The next question, Yvonne, will be the formalities. The formalities of a will in Texas is that it must be in writing. Now, we will talk about holographic will at a later time, but for purposes of this young man, this will was not handwritten. This will was typed up. And so the will must be in writing. That she satisfied that. The will was in writing. The will must be signed by either the testator in person or another person on behalf of the testator. So the testator is that person making that will. And this particular document was signed by the young man's stepmom. But here's the thing. Did she sign the will in the presence of a notary or a witness? That's the 2 questions that we had to deal with when it comes to that particular will that was brought to my office. Go ahead to the next slide, Yvonne. Actually, let's go back one more. Let's go back where we were before. So under Texas law, all of these elements must be satisfied. But then you have to deal with signing that will in front of 2 witnesses. And these 2 witnesses cannot be taken in your will. You cannot name them as beneficiaries and then they sign as witnesses. So the 2 witnesses that will sign have to have no interest in your will. They have to be at least 14 years old, and they need to be able to sign that will in your presence. So while you're signing your will, the 2 witnesses have to be there signing the will at the same time. The problem we have with that particular will is that it had no witness. It didn't have any witness at all. And so on its face, that will was no good. We could not probate it. So a will is important because it names and outlines everything that you want done at the time of your death. Who takes the house and how they're taking the house. If you have specific rules on how you want the house disposed, the will outlines all of that. Within your will, you would name an executor or an executrix if they're a female. And the executor's job is to go ahead and make sure that they probate your will. And in probating your will, they're working through every single recommendation that you've made within that will. Disposing the house the way that you ordered they be disposed within your will. And so the executor is an important person. You want to trust the executor that you name within your will. It's recommended within your will that you also name an alternate executor. The alternate executor would function or would come into play if the executor does not qualify. And so the executor that you name cannot have a felony. The executor that you name cannot owe you any money. The executor you name must have good moral character, otherwise they may not qualify to be your executor. And so you want to always have an alternate executor that would come in to take the job of the executor that you initially named, assuming the court does not accept that executor. So going back to this young man's stepmother's will did not satisfy the requirements of Texas law for a will. And therefore that will was no good. And that means that he could not probate his stepmother's will. And the next question is, well, what happens? What happens if that will is no good? What happens is that particular individual's property would now have to go through the statutory distribution system. And we're going to look at that document, Yvonne, that I sent to you, the link. So under Texas law, if someone dies without a will, but they're married with kids, the courts have designated a way to distribute the assets. And so if the asset is a separate property, and the separate property is property that you accumulate prior to marrying your spouse, all of the property that you accumulate prior to marrying your spouse is separate property. And under Texas law distribution, if you have no will, 2/3 of your property, your separate property, will go to your children, and 1/3 of your property will go to your surviving spouse. If you do not want that to be the case, then a will is important. You want to have a will prior to your passing, right? Under Texas law, if the property that we have are all community property, so the properties that you purchase during your marriage, Yvonne, if you scroll up just a little bit. So all of the community property, all of the property in the estate will be community property. And in that case, the surviving spouse gets half of the property and the children get half of the property equally. So this distributed amongst the kids, however many kids, equally. Now, if we're talking about real property and the real property is the property that the spouse lives in, then the children, of course, are not going to take half of it. The way the court works through that will be that spouse gets a life estate in the children's half. So the half that belongs to the children will become a life estate for that surviving spouse. If you're single, widowed with no children, the courts have designated a way to divide your property. It will be your surviving parents, half goes to dad and half goes to mom. If they're siblings, then half of it goes to mom and dad and the other half will go to the sibling. Again, if you don't want this to be the case, then a will is important. You want to outline a will and make sure that your will goes to the right person. Let's turn to the next page, Yvonne. Now, just briefly, if there's a passing and there's no will, but the individual is married and has no kid, then the courts also have decided that 1/4 of the estate will go to the mother of the deceased individual, another quarter will go to the father of the deceased individual, and half of the property goes directly to the surviving spouse. If there are no children and one parent survives the deceased individual, then we have half to the surviving spouse, 1/4 to the parents, and 1/4 to the siblings. And so the reason for outlining this to you guys, and I want to first, before I get off the screen, I want to make sure that I let you all know that this particular document was obtained from Collin County District Court, so it's not my document. So I want to make sure that we know that this is a Collin County document. And you are welcome to go on their website and print this, or I think maybe Yvonne might have it available for you. But this document is important because you're able to see what will happen if you don't have a will. But if you have a will, you're able to designate who gets whatever that you have accumulated. I want us to go back, Yvonne, to the previous screen before this one. We talk about holographic will. Now, sometimes money is an issue, okay? People don't have the funds to just hire an attorney and pay for all this estate documents. And so the Texas courts has made it possible for people to still have a will, and that's a holographic will. A holographic will is acceptable in Texas. In other words, you can sit on your table in front of the TV and handwrite your will. It has to be in your own handwriting. And it doesn't require a witness or a notary, but I always recommend if you're going to do a holographic will, make sure that you just at least have 2 witnesses. It doesn't hurt to have 2 witnesses. That way no one argues that it's not your writing, right? So Texas law requires that it be in your writing, and it doesn't require that you have a witness or a notary. The one question that a lot of people ask is whether or not a Texas will must have a notary. Does the notary have to sign a will for it to be valid if typewritten? The answer to that question is no. You don't have to have your will notarized, but you must have 2 witnesses that are independent and are not taken from your will. The reason why you want a notary, and you want your will notarized though, is because sometimes you can't find those witnesses when it's time to probate your estate. And so an attorney gets your will and it's time to probate your estate. And if your will is not notarized, we have to go and find those two witnesses. In a lot of cases, the will includes the signature of the witnesses, but it's not even legible. You don't know who that person is. It doesn't include a phone number. So we have to search to find who those witnesses are. To make it easier on your attorney and your loved ones, you want your will notarized. If your will is notarized, then your attorney is able to go to court, present your will, it's self-proven because that notary was present at the time of signing. Now, that's the first document, and that's the most important document. Within your will, I want to mention that there is one more document we're going to discuss at the end that we can include within your will. Any attorney can include a guardianship for minor children within your will. It designates who should take care of your kids at the time of your passing. I always say this, if there is no need to have a will, because some people argue, well, I don't have any properties to give. Well, if you have kids, that's enough for you to get a will done. You have that document that designates who gets to take care of the kids at the time of your passing. We'll go next to the next document will be our statutory durable power of attorney. Now, someone's driving down Highway 75 and an accident is an accident, right? We don't know when it ever happens. And the person gets into a car accident and bound. They can't speak anymore. They can't get off the bed anymore. They're in a hospital, incapacitated. They have bills to pay. They have transactions to make, their bank accounts. There are many things that they need to handle personally and financially. And so the one document that would be helpful in a situation like that is not a will, right? Because the will comes into play when you're passed. The statutory durable power of attorney will be the document. That's that document that outlines who gets to take care of your business at the time of your incapacitation. And so a statutory durable power of attorney is the most important document when or in the event we are unable to take care of ourselves. A statutory durable power of attorney would give a person, which that person is called an agent, powers to make decisions in most estate matters, which would be financial matters or property matters. Can you help me do this transaction? I have a closing tomorrow. I'm in an accident and I cannot move, right? That statutory durable power of attorney kicks in right when you become incapacitated, and that person can do the closing for you. I want to mention that statutory durable power of attorney needs to be, we need to make sure we understand the difference between a statutory durable power of attorney and the power of attorney that we all kind of like, I can just call my sister up and say, hey, Stacey, get me, I'm making you a power of attorney for me today, right? Because I want you to be able to go to my bank in Illinois, because you're traveling to Illinois. That particular document is different from statutory durable power of attorney. And so that document is called, you can either have it called a limited special power of attorney, because I'm limited, Stacey's ability to help me is limited to her handling that bank transaction in Illinois, and that's it, it ends, right? The difference between that power of attorney and the statutory durable power of attorney is that the Texas courts, the statutory and the durable power of attorney allows you to name the agent, and it becomes effective when you become incapacitated, and it continues even during your incapacitation, right? It continues. Again, that's different from the power of attorney where you just give someone the rights to transact the business for you, because it goes away as soon as that action is done. You also have a general power of attorney. Right? The general power of attorney is also a power of attorney that gives you a broad range of rights. But because it's not a durable power of attorney, it also ends, right? It doesn't continue. It ends when that incapacitation comes on. So for example, Yvonne decides to give Getsy a power of attorney, a general power of attorney. And it outlines a whole lot of different things that Getsy can do because Yvonne is traveling out of the country. Getsy has the ability to make all of those transactions on behalf of Yvonne. But at Yvonne's incapacitation, Getsy's right as a general power of attorney ceases. Again, unlike the statutory durable power of attorney, it continues. It kicks in when you become incapacitated or even before, but it continues after incapacitation. I have a couple questions here. Are we answering the questions? Do you want me to answer these questions now, or do we answer it at a later time? I just want to make sure I'm not ignoring anyone here.
Typically, we wanted to go ahead and wait for the end to get to the questions. I know that there's a lot of content we want to share with the group, but if you're comfortable answering them now, you may certainly do so. Whatever makes the most sense for you.
Okay, I would like to go through. Let me go through it, and then we can do a question and answer time. It allows me to flow better. Okay.
Okay.
And so thank you for your questions. I will get to all of the questions. I hope all of the questions at the end of the presentation. Yvonne, if you go on to the next slide for me, please. And just briefly, just like we have elements for a valid will, the Texas courts have elements for a valid statutory durable power of attorney. Number one, it must be in writing. Number two, you must name an agent. Number three, must be signed and notarized. Again, different from the will. The will doesn't require a notary. The statutory durable power of attorney, on the other hand, must be signed and notarized. And finally, it must say what the power of attorney is for. Like, what is your agent going to be doing? Now, I want to also mention that just like the will, it's important to also have alternates. Like if you feel like the first agents may not be able to serve for one reason or the other, or you want to back up, you're able to name an alternate agent in your statutory durable power of attorney or any type of power of attorney that you have in Texas. We can now move to medical power of attorney. So medical power of attorney is again similar to the statutory durable power of attorney. Again, we've talked about statutory durable power of attorney. We've talked about the general power of attorney, the limited power of attorney, right? Then this is the medical power of attorney. The medical power of attorney does what it says. In an event of incapacitation, your agent makes health-related decisions for you if you're unable to communicate your wish. And so this really means that you have discussed your wish with someone that you're naming within your medical power of attorney. This one has to be signed before a notary or two witnesses. And so it's important to note, if you decide that you're going to handwrite some of these documents, then you want to make sure that you're doing this notary or a notary and that you're paying attention. So a medical power of attorney, again, has to be signed before a notary, or you have to have two witnesses. And of course, you want to trust the witnesses that they would make decisions based on what you're telling them to do, right? Again, with the medical power of attorney, you want to name an alternate agent. It can be added in your medical power of attorney. You can also restrict your your agent's rights within your medical power of attorney. For example, you can say, I want my agent to only make decisions regarding whether or not I'm going to be able to get blood, right? Or you can just give them a general power to make decisions because you trust that they will do what you wish, what you've discussed with them previously. And again, this situation happens similarly. You know, someone's driving down Highway 75 and they get injured and unable to take care of themselves. They're unable to handle their personal issues, unable to handle their financial issues or medical issues. So the documents are separate. You want to get that statutory durable power of attorney, and then you want to add a medical power of attorney so that they are able to make decisions fully for you. You can revoke any of your power of attorneys. And so you want to revoke your power of attorneys via writing is what I always recommend. Or you just tell the person that you named, I don't want you to be my power of attorney anymore. Writing is always the best option. For your medical power of attorney, however, you can revoke by notifying the agent or your physician, but you have to notify your physician in writing or verbally. Now you can notify the agent. I always say notify them in writing. You get your power of attorney is revoked if you named a spouse in an event of a divorce. A power of attorney can also be revoked with a new power of attorney because typically there's a provision within your power of attorney every new power of attorney that revokes previous power of attorney. So the most recent dated power of attorney is typically the right power of attorney for you. Yvonne, we can go to the next slide. And I know that everyone, most of us, if not everyone, has heard about the HIPAA. The HIPAA is an important document. And so it's important because in some cases, you're not able to access documents without a HIPAA release, right? Medical facilities will not give you those documents. And so the document that a patient will sign to allow healthcare providers or third parties to access or use or disclose their protected health information is called a HIPAA release estate planning documents. And so this one is really easy. Why do you need this one? You need it because, again, in an event of a situation that we discussed earlier, you want to be able to, for whoever you name, you want them to be able to access your health-related information for one reason or the other. And so HIPAA release is another estate planning document that I believe really works well with that medical power of attorney. We can go to the next slide. Now, directives to physician. Sometimes this is confused, this document is confused with that medical power of attorney, but it's totally different. The directives to physician is also known as the living will. Some people say living will, some people say directives to physician. This is that document that communicates your wishes to your physician about the medical care that you want if you're unable to advise your physician orally due to lack of consciousness or any other reason. It needs 2 witnesses or notarized. The witnesses cannot be a relative. Your witnesses cannot own the facility that you're being treated in. So you go to a healthcare facility and the owners cannot be your witness. Your doctor cannot be your witness. Anyone who has a claim to your estate cannot be your witness. And anyone that has been given previous powers to make treatment plans for you cannot be a witness. So in other words, your medical power of attorney, the agent that you assign to your medical power of attorney cannot witness the directives to physician. Why do you need a directive to physician if you already have a medical power of attorney? After all, I'm going to tell my agent in my medical power of attorney everything that I want them to know. So why do I need the directives to physician? Well, listen, we need it because sometimes families have conflicts. So in a situation where there is a mom, there is a dad, there are sisters, there are in-laws, you have someone that's been appointed as a medical power of attorney that comes in and says, I want you to not resuscitate. Well, several other people have different ideas of what needs to happen. So the directives to physician really takes care of that problem because your doctor knows, your doctor has the living will that says, no, she wants to be resuscitated. So there's no confusion. And so the living will really comes into play when there is when there's a life-threatening situation. In other words, do we withhold or do we continue any medical treatments? And so that's the difference between that medical power of attorney and the living will. Okay, so we can go to the next one. All right, so declaration of guardianship. Declaration of guardianship is that document that sometimes it's just, we just put it on the back burner. It doesn't matter, but right? Who's ever gonna need this? Well, this is an important document. The first reason really is guardianship can be very costly. And what is guardianship? Guardianship is a situation where someone becomes incapacitated. There is no power of attorney. There is no medical power of attorney. In fact, they need someone to make decisions concerning their estate. They need someone to handle their person. So the guardianship is that document that's ordered by the judge that allows an individual. The individual is granted a letter directly from the court that says you have been appointed as the guardian of the estate and or the guardian of the person, of an individual who has become incapacitated. And so parents automatically have that right. Really, it's already embedded in us as a guardian of our kids, of our minor. But if we have an adult family member that has become incapacitated, or you have a minor that is incapacitated and is becoming an adult, they're 17 years old, and after they turn 18, everybody's going to give you problems regarding their care and control. What do you do? What you do is get a guardian, you file for guardianship. So you go to court, you file through your attorney, file an application for guardianship. Expensive process. You pay an attorney, filing fees is long. You have to pay so many different, you have to, in Texas now, actually go through a certification to be that guardian. And so sometimes there's just not enough time for you to go through the legal process just to get that one piece of paper. Well, what do? That's where the declaration of guardian comes in. And besides that, you might have 5 family members that are fighting to be your guardian, but only you know who would do the job well. And so why not, prior to that happening, having your estate portfolio, a declaration of guardianship. And that's that 1-page, 2-page document that would name an individual that you trust and you know would come in and handle your estate and handle your person with care. And so the guardianship, the declaration of guardianship allows you to designate by writing. Within your will, you can do that, who you want to be guardian of your person and guardian of your estate if the court found you legally incapacitated and in need of guardianship. Again, this can be for you. This can also be for your minor kids that are maybe incapacitated now and getting into becoming adults. We can move to the next one, Yvonne. All right, this document is, okay, we talked about this one while we talked about the guardianship of, declaration of guardianship. This is for your child. Surviving parents can name a guardian for their minor child's person or estate within their will. And it can also be for an incapacitated adult child or minor who is, of course, growing into becoming 18 years old. The recommendation I always say is start 3 to 6 months before your child turns 18 if you're going to need that guardianship for sure. And so you want to start filing your guardianship before the child turns 18. You want to name the guardian just in case something were to happen to you. All right, we can do the next page. All right, so the next topic here, I think you skipped one, Yvonne. Let's see if you go back one more. It's the supported decision making. Well, I can talk about it anyway. So
Okay, thank you.
okay, yeah. So the supported decision making document is that declaration. Wait, let me go back one more time. Okay, no, let's go back to the next page because I think I covered that. I covered it. All right, so the next document here will be the revocable transfer on death deed. So you own a property and you're the sole owner of this property. Real property is a probate asset. In other words, if something were to happen to you today and you have no will, then the real whether or not you have a will, the real property is typically named in your will, or if it's not named in your will, when they go through the probate process, the real estate comes into the probate document. But there are ways to get it out of probate. It's cheaper for your loved ones if most of your assets, if not as many as you can, if you can get them off of probate, it's cheaper, is smoother, and less stressful. And so this transfer on death deed is a simple way to transfer your real estate to someone else at the time of your death. So prior to your dying, you have a document that says that your real estate will be transferred on death to, and you name the individual. If drafted properly and recorded in the county records, you wouldn't have to add this property to your probate asset. Just the same way you can do this for your bank accounts. So within your bank accounts, you just walk up to your banker and you say, hey, I need a POD, paid on death. Again, your banker would add an individual's name that takes over the bank, the funds in the bank, if something were to happen to you. Why is this important? Well, probate takes time. Whether or not you have a will or not, it takes time. Now, of course, it's shorter if you have a will. When something happens, there are funds in the bank account, you cannot reach it. Your loved ones are stuck. They can't reach the money to pay the bill. Even if the court appoints them as administrator or executor of your estate, they still have to get through filing the case, going to get a hearing, looking for the right attorney. And so why not have a transfer on death, or why not have a paid on death that allows your loved ones to take over the bank account and access the funds that they need for several different things. And so the revocable transfer on death deed is an important document. And what's good about this is it's revocable. In other words, you can change your mind tomorrow. You can decide that you don't want Jane to be the agent that takes over. You can decide to put somebody else. But this is an important document. If you have real estate, get it out of probate. If you have a bank account, just walk up to the bank one day and get a POD. A quick addition to that. A lot of people have retirement accounts, 401k, have life insurance. Those particular accounts are not probate accounts. Guess why? Because they already have a designated beneficiary, right? When you have a life insurance, your life insurance agent already says to you who is going to take, right? You already named someone. Similarly, with your retirement accounts, there's already a beneficiary listed. So those accounts are not probatable assets. And so you can make your bank and your real estate the same. And we can go to the next. Well, the next is we are in question and answers. So I'm happy to answer whatever questions you have. I know that they're typed up here in the chat. Yvonne, would you coordinate this if you want me to go in chat and answer these questions?
I will certainly help you out here. I'm going to, if you don't mind, I'm going to stop my share for a moment. And I'm going to take a look in the chat box. And okay, so I do have a question. Okay, there were so many documents that were mentioned today. What are some of the most common that we would expect to see? Okay,
so, I outlined it based on what I felt was like the most important. So I would say the will for sure, right? We want to see the will. We see the will a lot. Then the power of attorney, the statutory durable power of attorney for sure, right? Now, the medical power of attorney, you want to consider whether or not you want to just talk directly to your physician, right? Or you want to deal with naming a family member that will handle the smaller issues. But if you wanted me to pick two documents, I would say the will and the statutory durable power of attorney. If you decide I should add two more, I would say the living will and the medical power of attorney.
Okay.
And let me add this to it. Mm-hmm. Listen, within your will, you can just tell your attorney, hey, listen, I want you to go ahead and add a declaration of guardianship for me and for my child. So somehow you've covered three within your will, and then you have the power of attorneys added.
Well, that actually is a great lead into an additional question, but I see another one that just came in front of it in order. So I'm going to ask that one first. How important is it to have a power of attorney over a estate?
How important is it to have a power of attorney over an estate? Tell me more. I don't quite understand that question.
Let's see. I'm going to, when it comes to having a power. So I want to defer to the person who wrote the question in the chat box. So I'm going to defer to Getsi Aredo. If you could come off mute, Miss Aredo, and clarify the question. And let me see, I'm trying to send her the unmute command.
Yes.
All right, there we go.
Okay. So just with the different types of the power of attorney, I know you said the one that started with an S, I'm sorry, the
statutory durable
statutory,
power of
yeah,
attorney? Okay.
stuff like that. So would it be better to have like that, the statutory one, or just like a regular like POE? Like what would be best?
Okay. I think I get it. So I say the statutory durable power of attorney, it would be better. Because it's not limited, but you can also within your statutory durable power of attorney just say, you name whoever it is to serve as my agent in the event of my incapacitation. So it kicks in when you become incapacitated. It's not there until you become incapacitated. They're not going to be able to do anything with it. So I say a statutory durable, but specifically your attorney names when it becomes effective.
Okay, thank you.
You're welcome.
And then let's see, I do have another question, but I want to also just remind folks, or actually tell folks for the first time, because I haven't reminded them yet, but Attorney Kafor was extremely generous, and she provided a gift certificate for a 30-minute consultation and drafting of your will and your power of attorney. Did I get that correct, Attorney Kafor?
Got it. Yes.
Okay. And so that has a value of, if you're a single person, $750 or more. And if you are married, it's $1,500 in value minimum just for attending tonight and going all the way through. And so we're going to raffle that off at the end. So in a few minutes, anybody who's here, you got to be present to win. So thank you again, Attorney Kafor, for the generous donation. And I'm looking forward to seeing who wins. I get my name in the drawing as well. Okay. I do have another question. What if you have property in a state that does not have TODD, or transfer on death deed?
Yes.
I believe that's what it stands for. How can you transfer the deed upon death?
That's a problem, and I don't like those states. And so what I try not to do is answer questions about another state, because somehow the United States has only given me the license to practice in Texas. And so what I would say is, depending on what state, I'm happy to do a little bit of research for you and find the right attorney for you to talk to. But if there is no TODD in that state, of course, you're not going to be able to transfer on death. And so it would just be you putting it in your will. Oh, in Alabama. I see her message here in Alabama. Okay.
Alabama.
It's just a quick question to an attorney up there. Maybe they have another option to do a TOD. The reason why this is important, and I think that most states will have their legislature pushing for this, is they want to help people not have to spend all the money and a lot of money in time of at the time of death. And so just like Texas has been gracious enough to give us TODD, I suppose there might be some other options in Alabama, but it would just be having to talk to a licensed attorney up there. Or naming it in your will.
And Mississippi too, I think, was also just mentioned.
Was it? Okay.
Yes. So I think the advice that you gave, though, carries over to Mississippi as well, talking to a professional in that state. Okay.
Yes.
I do have another question. This one actually is related to a document that you'd mentioned earlier. If you have a child with special needs, is there additional documentation needed for a child whose needs are going to go on potentially well after the parent's passing?
Yes. So I would say the trust is an important one, because of course, you know the best way and you know what's best for the child. You know, the best way to manage the assets that you've left for the child, instead of naming an executor. So the job of that executor will be to carry out your will. In addition to that, you want to name a trustee that's going to take over the property that you give to this child. And within your will, if it's not a lot of funds, right, we can put it within your will so you're not having to create a whole new trust document separate and apart from your will. Within your will, you can give specific instructions and duties to your trustee. And the job of the trustee is to follow through based on what you put in the will. And so the executor, you have the trustee, and that covers that child. And of course, the guardian of her personal estate. You may not need that trustee. No, you will need the trustee because the guardian of the estate, is guarding over making sure the bills are paid. But you want someone else to overlook the guardian of the estate, and that would be that trustee now, because the trustee is holding the bulk funds. The guardian of the estate says, hey, give me $3,000, right? I need to pay bills. And, they're working with each other. So I would say a trustee and a trust document that outlines how you want the funds managed. If you have a lot of assets that you're leaving for that child, I would say Rita will be that right person to talk to create those estate trust documents for whoever it is.
Mm-hmm, mm-hmm. And you're referencing Rita Dixon, who
Yes,
provided us expertise in our overview session last week. So,
yeah.
So great information for the folks who are here, that the content in this whole series kind of is woven together and is all interdependent. So it's really helpful information as you're planning on leaving a legacy to be able to attend all of the modules in the series. I have a related question about caring for aging parents. So what are the documents most needed for those of us caring for our parents? Is it the power of attorney or something else?
Yes, definitely the power of attorney. And you want the statutory durable power of attorney. Because I suppose if you're caring for parents, they have capacity now. So they tell you, no, I don't want this and I want that, right? So you want to create a statutory durable power of attorney that will say, in the event that mom is incapacitated, then it kicks in. That child, or whoever the parent names, becomes the agent to do the transaction, the agent to handle Social Security funds that are coming in, the agent to pay the bills at the house. That covers. And so within the statutory durable power of attorney, it's outlined a name, like what different things that the parents will want you to do when they become incapacitated. When they're not incapacitated, however, you can still have that power of attorney that allows you, not the statutory durable, but a general power of attorney that allows you to transact certain things that they are not most comfortable with. And so I would say the statutory durable power of attorney for sure, in the event they become incapacitated, but a power of attorney, just a general power of attorney that allows you to handle certain business that they can't or don't want to handle. And certainly the medical power of attorney, right? Sometimes you take them to the hospital and these clinics and these doctors don't want to talk to you because mom and dad are here. So the medical power of attorney would be helpful. I find that my clients actually come more to me for medical power of attorney than the personal and financial transactions. So medical power of attorney, the statutory durable power of attorney, if you're concerned about when they become incapacitated, but if mom and dad are not really able to handle their business now, there are issues with them handling the business now, then you want to get a general power of attorney that kind of outlines the things, go to the bank, that you are able to help them with. I say, if you are able to sit with mom and dad, if you have siblings, you guys have coffee one day, have lunch one day, sit down, let mom and dad tell you who they want named as their guardian, right? It saves you a lot of money. It saves you a lot of time and heartache, because every kid, in most cases, every kid wants to be the one caring for parent, right? Or else you have some people that want to do it for a different reason, right? And so you want to outline it and just narrow it down, let mom tell you who they want doing it, and you get a document signed so there are no conflicts at that time.
Okay, awesome. I do have a few more questions. Would I be able to indulge your time for a few minutes past 7? Are you available?
I'm available. I'm good.
Awesome. I just want to make sure we get to all the questions this evening. So I've got a couple more. So would the surviving spouse automatically inherit everything?
If there are no kids?
Let's go for both cases. In the case of children, in the case of no children.
So I'm assuming there's no will here. There's no will, and so we're going to the statutory distribution. Under the statutory distribution, if you're married and there are no kids, and you have community assets, the community assets goes, yes, 100% to your spouse. I'll tell you a story. we have some time. Can I take excuse to tell this quick story? It kind of paints.
Please, yes,
Okay.
absolutely. Please.
So very recently, I had a young man from Uganda come by my office, and he came by because his wife passed away in 2001. And his wife had about $170,000 in the bank account. And so he hired an attorney to go through probate. There was no will. So they had to go through the long drawn out process of a determination of heirship. That's what you file when there is no will. So application for determination of heirship. He hired another lawyer. And so they're in the process of filing the application for determination of heirship. The brothers of his wife showed up, went to his lawyer's office, and they say, hey, what's going on here? And so they talked. The lawyer called his client in, and they had a conversation and came up to an agreement. We're just going to divide this 170 in two. Family takes one, and the husband takes one half. And I wonder why the lawyer did this, but I kind of figured why. Because who knows, some of those assets may have been separate property, right? She may have accumulated those properties prior to marrying her husband. Nobody knows. And so in all fairness, they agreed that that's what will happen, half and half. Well, before the process ended, the brothers traveled to Uganda and showed up with a will that was dated in 2019. And at that point, the property, the will that came through from Uganda grants all of the 170 to the brothers. And so this young man is stuck. He comes to my office for a second opinion. And I say, if the will is found to be valid, then you get nothing, because the will says that they keep the 170. But you want to focus on the validity of that will, because if the will is not valid, then there is no will. Then the court will work this case based on the statutory distribution. And to answer your question, the statutory distribution in that particular case, he didn't even have to share that 50-50 with them. He gets 100% of it, unless they prove that those assets were accumulated and were her separate property. So to answer your question, yes, the spouse gets it all if it's determined to be community property. If it's not community property, then no, he doesn't get it all. Again, remember what we talked about. If it's not community property, he gets half, and then the other half goes to the family. Not necessarily the brothers, but mom and dad.
Wow.
Did I answer that question? I think I went around in circles. But...
No, actually you did. You did. And it's also a heartbreaking story just about all the complexities that come in when someone passes without their intentions being known.
And it's very sad because humans become greedy when money is involved. And so we want to make sure that we keep people, help people keep their integrity, right? And these documents help people to keep their integrity. Absolutely.
Now, what about your parents' property? What do we need to do to ensure they can pass on their property in death?
Encourage your parents, if they have capacity, if they understand what assets they have, if they understand who their kids are, encourage mom and dad to get a will, right? And so sometimes that's the most difficult part of it, because like mom and dad are looking like, why are you asking me to get a will, right? But it's about education. If there are forums like this, lock them in, let them hear. Then they call the attorney on their own, because the most difficult thing is you wanting your parents to do it, but no attorney is going to stop the process because you call them to create a will for your parents, right? So because the parents are the clients. Now, surely if your parents walk up with you to the attorney's office and they say, hey, I'm here to do a will, and you excuse yourself, maybe that will work. But you want to educate them, they need a will. That's the one way to do it. Otherwise, whatever they own at the time of their death becomes probate assets that would perhaps in some cases turn into a terror for the family and conflict all over the place because someone thinks they need to get the gold clock or whatever. So they need to have a will and name all of the items that could potentially cause a problem. And important too is they need to put in there a clause that says, if you contest my will, you get nothing. Guess what? People behave. So you can put in your will a clause that just says, listen, this is what I want. And if you want to contest it, you get 0. And so everybody behaves themselves because they don't want to get 0. So again, encourage mom and dad to just go to an attorney's office and encourage mom and dad to ask to include that provision if there's a chance that there's someone out there that might cause a problem.
Spicy, but I like it.
Mhm.
Can you have more than one person as durable power of attorney?
That's a very tough question. The answer is yes, you can, if you name the second and alternate. In some cases, people have named both people. I mean, 2 people in there, and it becomes an issue because, as you can imagine, 2 people are named power of attorney, and 2 people show up for a closing. Like, who's going to do the power of attorney, right? It's confusing. So some people do that because maybe one person is likely to be in Nebraska and another person's here. You know, some people do that. I don't recommend it. I always say, let's do one at a time. If the first one cannot serve, your alternate kicks in.
Okay. I'm going to do 2 more questions, I promise, and then I'm not going to impose on your time anymore. So the first one is there a limit to the number of executors or trustees that can be named in a document, probably related to the previous, a committee to ensure that named persons are executing the wishes properly and to prevent mismanagement?
What you're trying to control, if that's done, is already controlled by the court because when you have a will, the will names an executor, right? The alternate executor is not overseeing the executor. That's not the job of that alternate executor. The court is overseeing that executor. And so similarly, when you have a trustee, right, the alternate trustee could have that effect, but legally, that's not their job, is to oversee the trustee. But anyone can file. So for example, if you decide that you're going to name 3 people, and you have that as a reason why you're naming the 3 people, then what will happen is the other 2 people are asking questions. They're not necessarily serving. And
you were in the middle of answering your question. So
right. So what I was saying is they're not really overseeing the trustee or the executor. The court's doing that. So the court's checking in every year. That executor is required to file paperwork, right? To make sure things are done right, file inventory, and everyone's seeing it. And so the court's doing the overlooking. But if the alternate trustee or whoever else is in the family notes that the other party is doing, well, the named trustee or the named executor is doing it wrong, they can quickly file a motion to remove the named trustee, motion to remove the named executor. And you go in and do a hearing and say why. There is also a bond. So the court requires bonds for the executor. If they're doing it wrong, there's that bond that covers. But to answer that question, you can name 3, I would say name the main trustee, name an first alternate, second alternate, for purposes of just kind of looking at what's being filed. But the court is not the all 3 of them can file at the same time, but they're there to make sure that they're looking and they can file a motion to remove them. Did I answer that question?
Yes, I think you did.
I don't know if they have a follow-up to that one.
They had the committee question as part of that as well. Does that kind of apply then with additional? Well, actually, we just got a thumbs up from the person who was asking the question. So it sounds like we did answer Ms. Chauvert's question. So thank you, Michelle, for confirming. And then I do have one last question for you. I promised we'd only have 2 more, and this is my last one. What if there's no will but blended families?
Oh, that's a good question. And I'm glad that we didn't forget to talk about the blended families. Listen, the blended family is a beautiful, beautiful structure. But I find that that's where I have the most issues. And so what if there is no will and we have a blended family? You already know that it's complicated, right? It's already complicated because the husband's family, the spouse, the husband has kids that feel like they need to take all of dad's stuff. On the other end, the wife, they feel like they need to take all of dad's stuff. So quick example, if both parties purchase a real estate during a marriage, it's a community, that's community asset, right?
Mhm.
That community asset goes to the wife. If something were to happen to husband, the community asset goes to wife. But guess what? The husband's half is going to wife, not entirely. The wife has what they call a life estate, so that the kids don't come and kick her out of the house. She has the right to live in that house forever until she passes. But they still have an interest. So they come back at your passing, and it becomes an issue with the wife's children. It's so complicated. There must be a will. I always think that if there's a blended family for no other reason, just to keep sanity in place, there must be a will. So there, for that particular question, what if there's a blended family? There are lots and lots of scenarios. And so I like to, if the person wants, we can have a conversation over the phone, but there's tons of scenarios. You don't want to pass a blended family without will. Both parties need to have a will. It clearly defines what's going to happen to husband's half, what's going to happen to wife's half, or is the husband says, if I pass, all of my interest goes to my wife. There's no life estate, there's no issue. It goes directly. And then you both can, I recommend just buy a life insurance. Man buys a life insurance that takes care of his family. Woman buys life insurance that takes care of her family. And then that house, if something happens to dad, goes to wife, right? But that particular house, we could say wife lives in that house. If something were to happen to wife, it needs to be divided equally amongst all the kids, right? But here's the problem with that. If wife is not trustworthy, as soon as husband dies, you see what could happen to the agreed will. Like, it's not a contract. She can go back and change and say it belongs to me. So to take care of the two individual families, life estate is good. Or you could say, if you have two real estate, one's going to go to the wife's kids, one's going to go to the husband's kids. If there's only one, then we can say, well, we need to be able to have maybe the funds in a bank. There are different ways to work around it. That particular question, again, has tons of scenarios, hard to answer it.
No, you answered my question very well.
Thank you, Randy, because I felt like I'm like going in circles. I didn't
No,
have a
you
thought.
did. You answered my question very well. It was just like, it was so many scenarios, and I just had one add on to that. Specifically, the wife has children from a previous relationship, the husband has children from a previous relationship, and then they have that one blended, a child from their union together. That child doesn't supersede the wife's children from a previous relationship or the husband's children from a previous relationship, does it?
If no will and you're going through Texas distribution, no superseding. So
Okay.
They distribute based. If you don't have a will, then the Texas court takes that child as, it's all, they're all the same.
So that child that they had together won't win it all, and then the other children would have to, fight that one, correct?
No. So if that scenario happens, where assuming husband is passed, wife is passed, we have that one property.
Mm-hmm.
It's going to be divided in half. All of wife's children likely get her half. All of husband's children likely get his half.
Okay.
But it's so expensive. It's so complicated, like it's crazy. Okay. It's like
all in all
crazy.
Have a will.
Huh?
All in all,
Yeah.
just have a will.
Yep.
Oh,
No
yeah. It's pretty crazy and expensive. So by the time your attorney is done figuring out who is even taken, I mean, you spent 1/4 of the assets. So it doesn't have a will.
I think you're
Thank
right.
you.
Yeah, thank you,
You're
Randy, for
welcome.
that question. Fantastic question. I think you're right, Attorney Kafor. It just sounds like our blended families are beautiful, but we definitely need to make sure we're protecting them with the appropriate documentation.
Yes, absolutely.
Well, I appreciate you answering those questions. Fantastic answers. Also, really fantastic questions from our audience. Thank you guys for being so engaged. I want to thank Attorney Yvonne Kafor for gracing us with her presence, her expertise, her knowledge, and lots of patience for answering lots and lots of questions. There's so much information that goes into leaving a legacy behind, but it's absolutely necessary that we learn this stuff and take care of our community. So thank you again, Attorney Kafor, for being here this evening. Next week, because we're going to continue our legacy planning series with a conversation about financial planning. And the speaker next week is going to be Mr. William White, who is also a colleague of Attorney Kafor's, and they know each other quite well. They work together quite a bit around planning for their mutual clients. So we have a lot of expertise coming to you with these speaker series, and so we know you're going to enjoy them. So so stay tuned for next week, which is financial planning again, and then on the 28th, the week after that, we'll be talking about bereavement with Chaplain Tanya Hatchett. All right, y'all, thank you so much for joining again, and have a fantastic night.